I'll take it later on.
By you not taking it this morning, will it affect your ability to understand what's going on in this plea?
No, ma'am. No, ma'am.
How old are you and how far have you gone to school?
I'm 53 years old. I went to graduate from high school, trade school.
And are you able to read, write, and understand the English language?
Yes, ma'am.
In case number 20 SC 174630, do you understand that you've been charged with? I'm sorry, Your Honor. The state is reducing the aggravated assault charge to simple assault on this case, and on the 2006 case, the 06 SC 40288, the state is reducing the trafficking of cocaine to possession of cocaine with intent to distribute. I apologize, Mr. Edmond. Do you understand in the 20 SC 174630 case, you have been charged with aggravated assault being reduced to simple assault?
Yes, ma'am. Yes, ma'am.
And in 06 SC 40288, do you understand that you've been charged with trafficking in cocaine being reduced to possession of cocaine with intent to distribute?
Yes, ma'am.
Do you understand that you have a right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am. I understand.
Um, as far as case 20 SC 174630, have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, 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 ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, yes, ma'am.
And pertaining to case 06 SC 40288, have you had enough time to speak with your attorney, Ms. Snyder, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
Well, I had went over and discussed it. Say probably in my best interest with this with '06 case. You know, with my trials or whatever, I probably have to go on. It'd probably be best to go on without leave the trial out. Even though I never knew I was arrested for it, but I go on plead out to the 2 years probation.
I understand, Mr. Edmond. I understand this is going to be an Alfred plea, but do you need to talk to your attorney a little bit more about the case, or do you feel like you've talked to her enough?
I talked to her enough. I just want to get it over with.
Okay. And are you satisfied with her services?
Yes, ma'am.
Thank you. Mr. Franklin, pertaining to 20 SC 174630, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, for purposes of this plea.
Okay. Mr. Edmond, on the aggravated assault case, have you been arrested on those charges?
Yes, I have. Yes, I was arrested on those charges.
I asked because the state is unaware of any outstanding warrants that are related to this charge. Do you or your attorney know of any outstanding warrants related to that charge?
We're not aware.
And has your attorney advised you of the minimum and maximum 1 to 20 years to serve on the aggravated assault charge?
Yeah, yes.
I thought it was being reduced.
Sorry. Yes, I'm sorry. Thank you, Your Honor. Mr. Edmond, has your attorney advised you of the maximum for the simple assault to 12 months to serve?
That's the sentence of it, the 12 months.
The maximum on the simple assault charge is 12 months to serve.
That was informed that I was the plea that to go from simple assault time served.
Yes, I just want to make sure you understand that the
yes,
most
yes,
on that.
Yes, ma'am.
I just want to make sure you understand that the most that you can receive on that charge is 12 months to serve.
Oh, yes, ma'am. Yes, ma'am. Thank you.
Okay. Ms. Snyder, pertaining to case 06 SC 40288, do you waive formal reading of the indictment?
She waived it.
Okay. Do you waive any and all defects in the indictment, including with respect to the defendant's name? And do you waive moving forward on a copy of the indictment? Mr. Edmond, on the case for the trafficking of cocaine, do you have you been arrested on that charge?
I never knew I was arrested on that charge. I had discussed it with the lawyer, but I never knew. But no, like I said, I don't know what happened to the due process a long time I was arrested, because I never did go back to court on it some years ago if I was arrested and charged with it. So I never understood.
I asked you that, Mr. Edmond, because I just want to make sure that you or your attorney are not aware of any additional warrants that may be out there that's connected to this particular case.
I never knew about any other warrants that was on this case.
Okay. Has your attorney advised you of the minimum maximum for your possession of cocaine with intent to distribute being 5 to 30 years to serve?
Yes, ma'am. She advised.
And do you understand that for pertaining to case 20 SC 174630, this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months to serve 90 days, reduced to time served, balance suspended, but the court does not have to accept their recommendation. The court can sentence you to the maximum on this charge, which is the 12 months that I mentioned earlier. Do you understand?
On what charge?
This is the simple assault charge.
The state want me to serve 12 months on it.
Mr. Edmonds, she's going over saying, do you know what the maximum potential sentence is? We still have the agreement that you and I spoke about today.
Oh, okay, yes.
He wants to make sure the range is.
Oh, yes, I agree with the plea.
And Mr. Edmonds, as far as case 06 SC 40288, you understand that this is also a negotiated plea of guilty, which means the state will recommend to the court a sentence of 2 years probation, but the court does not have to accept their recommendation. The court can sentence you to the maximum on that charge, which is the 30 years to serve.
Yes.
Do you understand that both of these convictions are permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, I understand.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am, I understand.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am, I understand.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am, I understand that.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, I understand.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am, I understand.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Pertaining to case 20 SC 174630, is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charge of simple assault in indictment number 20 SC 174630?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Pertaining to case 06 SC 40288, are you pleading guilty because you have decided that it's in your best interest to do so?
Yes, ma'am, I have.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
How do you plead to the charge of possession of cocaine with intent to distribute in indictment number 06 SC 40288?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, I'm sorry. For indictment 20 SC 174630, had that case proceeded to trial, the state would have proven that on January the 16th, 2020 at 1636 West Lake Court, Northwest in Atlanta, Georgia, Fulton County, officers were called out to that address and spoke with the victim, Ms. Greer, who told officers.
Keep going.
Told officers that she had an altercation with her former boyfriend, that he came into her apartment and demanded her to give him back some chicken that he had given her. At one point, he did have a knife in his hand. Before the police arrived, he had left the scene, Your Honor, and he was positively identified by the victim by a photo of his, and he was later arrested. That is all in that case. And Your Honor, the state moved forward on the 06 SC 40288 case. The state was proven that on January 26, 2006, at 226 Ralph David Abernathy, that's Atlanta, Georgia, in Fulton County, an officer was at that location when he observed.
There's on the phone that you can hit that mutes everything behind you while you're not talking because you hit the mute button.
He did. I think he just did.
I muted him.
Oh. I'm sorry, Your Honor. Officer was at the location because he received information that a black male by the name of Dirt was selling cocaine from his vehicle. He arrived at that location. He observed a male was in the driver's seat of that vehicle who later went into the store. Another gentleman the officer got out of his vehicle and looked into the vehicle that was parked, and he saw drugs in plain view. He went back to his car and observed. He saw another gentleman that was not the defendant go to the vehicle and looked like he was putting something under getting something or putting something under the seat. At that point, the officer did stop the individual. Cocaine was located under the car. That person, his name was Kenneth Hamilton. He told officers that the defendant told him to go to the car and to go to this car to get some cocaine that was under the seat. The individual that the officer saw go inside the store, they never were able to catch him, which they later identified as Mr. Edmond. And it was warrants were put out for his arrest. I know you can understand that by him saying that he never understood why he was arrested for these charges, because he was not on the scene and arrested on the scene when this happened. That is all from the state, Your Honor.
Okay. Is there anything from Ms. Greer, either that you've got, Ms. Hall, or that Ms. Rolak has?
Miss, I'm not sure if Ms. Rollick has a statement. We have spoken with her a few times in the past, but I'm not sure she has a statement for our plea today.
Good morning, Judge. No, I don't have a statement. We've spoken to her several times. She has declined to make a statement.
Okay, thank you. Just wanted to check in case you wanted to be heard. I appreciate that. Ms. Crawford, welcome back. We missed you yesterday. What do you have for criminal history for Mr. Edmond?
Judge, for Mr. Edmonds, he has all of these cases are old and closed out. There's a 1997 possession of cocaine case. Then there's a 1988 violation of Georgia Controlled Substance Act.
What was the year?
1988.
88, okay.
And the last one is a 2000 case, case number 01SC11925. That's also a possession of cocaine. He doesn't have anything active at the moment.
All right, so 3 felony convictions out of Georgia.
That's correct.
And they're all pretty old. Okay, thank you.
You're welcome.
Mr. Franklin, anything you want to add on the assault case?
Just very briefly, the court's aware he is employed, as you can tell by what's behind him in his screen. He works at Tecton Inc. He does construction labor work. The circumstances that led to the confrontation or his arrest, actually, he and Ms. Greer had broken up, but he still had some items amongst them, some chicken that he had left in the freezer. The police were at the scene that day, as I understand, because he had called them to be present as he got some things out of the home. And that's when they became aware of the fact that she had made a call a few days prior or so, and that there was a warrant out from the earlier instance. But I think the fact that he was demonstrating that he was trying to get his things in a non-confrontational manner is what allowed us to get to the negotiation and reduction that we have gotten to, and the suspended sentence in light of the fact that there's going to be probation on the felony case to prevent reporting on 2 separate probations.
Okay, makes sense. Ms. Snyder, what would you like to share concerning the 06 case?
Your Honor, this case is significantly older.
You may need to get to one of the microphones so that Mr. Edmond can hear you. Sorry about that.
This case is very old, and we've had discussions about the state's reduction of charges and the risks of going forward on a trafficking charge versus entering the plea, and he's ready to move on with his life, so we have to choose.
Okay. Mr. Edmond, anything you want to add? I know one of these cases is real old. You don't remember anything about it. One of them is recent. You and I know more about it because we've had bond hearings and things like that. Anything you want to add? Oh, you're on mute, Mr. Edmond. You may need to unmute your phone.
Oh, okay.
There you
Yes,
go.
sir.
Anything you want to add?
No, sir. No, sir.
Is Ms. Greer someone who is still in your life, or have the 2 of you gone in different directions?
Been in different directions.
Okay. When's the last time you saw her?
My uncle still lived in the apartment that she lived in. I seen her at the grocery store. I seen her at a Kroger. on
Okay,
Cascade.
that sounds like that was accidental or incidental. Have you guys seen
Yes,
each other
yes, it was.
purposely, like had a date or anything?
No, sir.
Okay, that's all done. Ms. Hall, you didn't say anything about a stay away. I guess there aren't really conditions, because there's not probation, so that's why. Okay. Well, Mr. Edmond, I find there's a factual basis for your pleas in both your cases, and that your pleas are knowing and voluntary. Knowing means you've understood all the things we talked about. Do you agree with me, or do you still have questions?
I agree with you.
Okay.
I agree with you.
Voluntary means that no one's forcing you to enter these pleas, but you've decided after talking with your lawyers that it's probably the best way forward for you. Is that true?
Yes, sir.
All right. Then I will accept your pleas in both cases. You've entered an offered plea in the drug case, and you're certainly entitled to do that. That's when you are telling the court that you don't necessarily agree with what the state said happened in the case, but you've decided it's in your best interest to work it out anyway. Is that a fair description?
Yes, sir.
So
Yeah.
you understand that'll still show up as a conviction?
Yes, sir.
Okay. All right. Then I'll accept it as an offered plea. And in the case of 20 SC 174630, which has been reduced to simple assault, I will sentence you to 12 months to serve 90 days. I'll reduce the 90 days to the time you've already served. You may have been in for that long. How long were you in?
From January 20th until I think April 10th, April 11th.
It was like 79 days, I believe, was the total.
Okay. Well, 90 days, reduced to time served, so you're not going back in, and I'll suspend the balance. So that case is closed out. And in the 06 case, 06 SC 40288, you are charged only in count 1. That's been reduced to possession with intent to distribute cocaine, and I will sentence you to 2 years. I will probate those 2 years, so it's 2 years probation, and I think that's it. I am sentencing you pursuant to the Probation Options Management Act, and all that means, Mr. Edmond, is that while you're on probation, if you have a little problem, and I hope you have none, but if you have a little problem, maybe you miss a meeting or you're not reporting in some way, you and probation work that out. The only time you and I would get back together on this would be if you got arrested again for something else. Do you have any questions about that?
No, sir.
You may have already asked this, Ms. Hall, but I'm going to ask it again. Mr. Franklin, are you okay proceeding with a copy of the indictment?
Yes, Your Honor.
And Ms. Snyder, same question?
Yes, sir.
All right. Mr. Edmond, if you were here in court, you would sign your indictments. That's how you would indicate your guilty plea. Do you authorize me to sign for you?
Yes, sir.
Ms. Snyder, may I sign for you?
Of course, Judge.
Mr. Franklin
Yes.
and Ms. Hall?
Yes, Your Honor.
I will do that. I think the last thing we need to do, Mr. Edmond, is you're going to need to give some information about your address to Ms. Crawford, who you can see on the screen there. She is with probation, and she's going to give you probation reporting instructions, okay?
Yes,
Judge,
yes, sir.
are you able to put us in a breakout room so that I can hear him and get the information from him real quick?
Sure, why don't we do that? So, Mr. Edmond, you are going to move into a space with, see if I can get this right. Challenged by this. Let's see. Move to breakout room 2. And Ms. Crawford, move to breakout room 2. Show 2. And it's all right. Mr. Edmond, you should see a little button to press asking you to go to a breakout room. That's where you and Ms. Crawford are just going to talk a little bit about your address, okay?
Yes, sir. Go ahead.
Well, if you see the button, press it.
Okay.
All right, that seems to have worked. All right, what do we know, Ms. Patel, about Jonathan Johnson?
I was able to reach him, his phone number had changed, so he did not know he had court today, but he indicated he's on his way. And so it should still move forward as a negotiated plea.
Okay, and how about Ms. Jacobs?
I'm hoping she'll be here. The numbers I have for her and the numbers on Odyssey, I've left messages. Maybe, hopefully I'll have a message when they get back,
Okay,
but it should be a PTI.
all right. Then, Ms. Hall, I'm going to ask you to sit in as Ms. Hodge on the conversation we're going to have with Attorney Gregory. It's not going to be about the substance of the case, but I don't see Ms. Hodge on the call, and we can at least handle this so that all that's left is Mr. Johnson.
Okay, Your Honor.
All right, so Mr. Gregory, you ready?
Yes, Your Honor, I'm ready. I'm just trying to ascertain how I'm going to get my exhibits presented before the courts.
So I think now you should be able to, under the share screen function, share whatever you want to share. You're also welcome to tell me what you want to tell me. We're working through a couple things. One is who is going to be Mr. Peck's lawyer, and then 2 is where have you been? You've been hard to track down, and we just need to figure out what's going to happen with Mr. Peck's case.
Okay. Are you ready for me to present?
Yeah.
Okay. Let me go here. Yeah, I'm going to switch my to my iPad. Join with video. Sign in again. All right, great. Thank you, Your Honor. Hello? Am I on? Okay, I don't see anybody. Okay, great. All right, Your Honor. So I'm looking at the show cause order here that was issued out on the 18th of August of this year. It mentioned a few other, it mentioned 2 court dates that I had a valid leave of absence for. I don't know why it mentioned it because it was a valid leave of absence, but it did list that. So I guess the only concern here is the court date, the trial, I'm echoing, the trial court date for it says the trial was supposed to begin on December 16, 2019, and the state announced ready for that calendar call.
Yeah.
And it says Isaiah Gregory, attorney for defendants, that have provided a similar announcement after having been on the case for nearly 8 months, starting motion to withdraw. So that's not correct, Your Honor, respectfully. That's not correct. And that's why my exhibits are here to support. The trial date, and if you need if you need me to show my exhibits, I can to support my argument. But the trial date was not for that, not for that July 16th. Let me see here. Okay, so that court date was for the. Let's pull this up. I'm having a hard time trying to pull this up. Okay. I'm sorry, Your Honor, bear with me. I'm just trying to make sure I'm reading all this right. Okay, I have a 7/29 court date set for this case. It mentioned that, yeah, I have the 29th as the court date. I presented for trial in regards to this case with Judge Reeder, and we didn't actually withdraw from the case. We withdrew from the case on the 13th. The 16th is actually when, because I went to the court the day prior with Judge Reeder, and I presented myself for trial, and the defendant was not there. The reason for my motion to withdraw, Your Honor, is because I have not communicated, me and my officers have not communicated with my client this whole entire time. And
why is that? Mr. Peck's not hard to find. He's sitting at the jail.
Yeah, well, he's sitting at the jail now, Your Honor, but prior to him sitting in the jail, we haven't had any communication with the client or anything with that. I was able to get a really good offer for the client, but I presented myself to trial. He wasn't there, so the judge did inform me. She said, she's going to put out a judicial hold on him, being that he wasn't present for his own trial date. I was there. I was present in court. And so my office on the 16th sent the courts a courtesy copy of our motion to withdraw. And I guess that was entering from there, but we filed it on the 13th. The motion to Mr. Peck was arrested on the, okay, let me just pull up my emails here because I sent my exhibits. Sent. Okay. So this is my first exhibit right here. Well, this is my trying to navigate through all this.
So, Mr. Gregory, I'm going to try to streamline this a little bit.
Yeah, I'm trying to
figure out why you come to court in July of this year. It was not for a trial calendar. It was a status calendar to try to figure out what's going on with representation of Mr. Peck. So that's one thing. Frankly, to me, that's a little less important because I've got you now at long last. What is more important to me is what are we doing with Mr. Peck's cases? Your motion to withdraw has not been granted, so you remain attorney of record. Mr. Peck is not hard to find. If you got this great offer for him, have you and Ms. We have two cases, so you have to work them both out. But what can we do to move Mr. Peck's cases along?
We're ready to resolve the case, Your Honor. You know, he's in custody now, so it'll be no problem for me to go down there and visit him. I was in front of Judge LaGrua, was it last month, in regarding this case, and Judge LaGrua, and I was present, and Judge LaGrua on the record spoke and said, if the client is not present on this court date, counselor, then we're going to grant your motion to withdraw.
Say that last part again, Judge. What does Judge McGrew have to
Judge
do?
McGrew. Judge, I presented for this case, the 18 SC case regarding Mr. Jerry Peck. Judge LaGruer had it, and I presented myself.
All right, you've lost me on that one. I don't know why Judge LaGruer would be handling Mr. Peck. But what I am hearing you say, and this is music to my ears, you think that it may have been worked out if we put it on a calendar. At a minimum, we could get you and Mr. Peck and Ms. Hodge and myself talking about what's going on with the case. Is that accurate?
Yes, that's correct, Your Honor.
Okay. Let me look up his other case. Ms. Nelson, the other case you have listed doesn't come up as it can't be 17 SC. It must be, is it 19 SC or is it 18 SC? Is that
Let me check right quick.
Hmm?
Let me check right quick, Judge.
Okay.
Are you referencing to both of Mr. Peck's case?
Yeah, I'm trying to figure out the number for his other case because what's on the calendar is not working. Now it's working. It must be an 18.
He has a, Your Honor, he has a 17 SC 153243 and an 18 SC 159101 is what I have.
Okay. Say the 17 number again, please.
Yes, Your Honor, 17 SC 153243.
Got it. That was one number off there. 153.
And Your Honor, I don't believe that the defense received discovery in this case as well. We haven't received all the discovery, I can say, for both of these cases. That would be helpful just for the due diligence of this case.
Sure. Okay, so the 17 SC case is family violence battery. So that's a less complicated one. And then we've got the case on the calendar where the allegation is rape. Okay. So tell me, Mr. Gregory, what you think is the most productive way to move forward here? Should we set this down for a calendar date where you and Ms. Hodge and Mr. Peck and I can talk? Which case do you not have discovery for?
Both cases, Your Honor, honestly.
Well, this was a case on a trial calendar back when Judge Reeder had it. It was going to go to trial in December last year. You're saying you didn't have discovery?
We had limited discovery, Your Honor, but I'm understanding when I was speaking to the client at the time that we didn't have everything that was part of the record. And so we did make that subsequent request and never received it.
Okay. So was Mr. Peck a bench warrant for a while? Was that part of the problem?
He was under judicial hold.
I don't know what that means, meaning no one knew where he was?
No, that's correct, Your Honor.
Okay.
And that's correct. And when I went to when I presented in front of Judge Reeder, she did issue that bench warrant out because he wasn't present and that we couldn't locate him.
Okay. And then it was only in January of this year, it looks like that he got picked up because here's where judicial hold was lifted. Okay, so So in December of last year, when this was supposed to be a trial, was Mr. Peck, did he not show up for court?
That's correct, Your Honor.
Okay. All right. So we may just have a big reset here. You're still on the case. You now can meet with Mr. Peck. You're saying that you may not have all the discovery. I don't want to have to get in the middle of the discovery discussion unless it's necessary. So can you and Ms. Hodge confer about what you've got and what you don't? And we will set these two cases down for a status hearing a few weeks out to figure out what still needs to be done. Does that work for you?
Yes, Your Honor. I'm just respectfully requesting that I could be sent into a breakout room with Madam Hodge so we can discuss this case.
Well, I'd love to do that. Madam Hodge didn't dial in today, though, so
Okay.
that's the problem. So we'll make sure Ms. Nelson is going to get an email out to Ms. Hodge and to you, saying that you all need to huddle up about discovery and what's going on with the two cases, the 18 SC and the 17 SC, and then we'll figure out what the right next step is, so that we can keep it moving.
Okay.
Ms. Hall, anything you wanted to add from the state side?
Nothing from the state, Your Honor. Well, nothing from the state, Your Honor.
Okay. All right. So, Mr. Gregory, you're still on it. Your thought is it might be work outable. I have no idea. That's for you and Ms. Hodge to discuss. But certainly, if there's some discovery you don't have, we need to address that so that we're in a position to do something with the case. All right.
All right. Thank you, Your Honor.
All right. Take care. Oh, hold on one second.
You can retained on the CP case as well, because it looks like my office is assigned, so I would like to know if I need to be.
Oh, Mr. Peck has a third case? Mr. Peck. Do you know, Mr. Gregory, if Mr. Peck or his family have retained you? He has an unindicted case as well.
This is my first time hearing about that.
Okay. Your office is on it right now?
That's what Odyssey is showing, it's one of the non.
Okay. Yeah. Okay, so Mr. Peck was on bond for this and then got scooped up on new charges. Uh-oh. All right.
And Your Honor, the new charges are similar to the charges in the calendar.
Yes, I'm remembering now about Mr. Peck. So he's got a new rape case as well. So it may be that things are not as easy to resolve as they may have been in the past. So, Mr. Gregory, why don't we do this? I'm going to give you 2 weeks to figure out.
Judge?
Yes.
Judge, I'm sorry to interrupt, but Ms. Hodge is going to sign on. I'm sending her the information because she would like to go to a breakout room with Mr. Gregory. So if you can hold for her to join for a minute.
Ms. Hodge was going to try to connect to this call, Ms. Nelson.
Yes, she's in the process of doing that. We had to resend it since my typing is, I can't see what I'm typing. It's too small. There it goes. Just give us a sec, Judge.
Thank you. Well, we're going to move on. When Ms. Hodge connects, I'll put the two of them in, but we've got other stuff we need to do. Mr. Johnson is here, so let's get Mr. Johnson up here.
Hello.
Hey, Ms. Hodge.
Hi, Your Honor. I apologize. This calendar was not on my radar. I have been able to listen to some of it. Can you hear me?
I can hear you. Can you hear me?
Okay. Yes, I can. And now I can see you. Well, I could see you. Now I can't. However, I wanted to respond to some of the things that I heard regarding the Jerry Peck case.
Okay.
So it's Mr. Peck was scheduled for, and I apologize, I'm not in front of my computer, so I don't have specific dates, but he was scheduled for trial in 2019 and failed to appear on that trial date, is my understanding.
That's right. In December.
Right. And shortly thereafter, he picked up a new rape case. So
Yes.
it's my understanding he has the case that was scheduled for 2019 and a new 2020 rape case. I don't know if that 2020 rape case has even been indicted yet. Because it happened. It has not. Okay. So that is my understanding of what's going on with Jerry Peck. Defense counsel should have all the discovery in the original case because it was scheduled for trial. And my records indicate that defense has all of that discovery. Now, he may not have all of the discovery on the new case because that case is, the investigation has somewhat been paused because of the pandemic, in addition to not knowing whether or not this attorney was the defense attorney on the case. because he did not appear in the last 2 court dates that we had on the calendar for this case.
So Mr. Gregory and I have talked about that. He had leaves for a couple of the dates, and we decided just to move beyond why he wasn't here in July. He's indicated that he recognizes he still represents Mr. Peck in the 2 cases that have been indicted. There's a family violence battery matter from 2017, the rape from 2018. He remains counsel of record for both those cases. He was unaware of the new charges for Mr. Peck and wisely did not commit to being his lawyer for that. Ms. Snyder, who's here in court, indicated that Odyssey suggests her office, at least temporarily, is representing Mr. Peck on the unindicted charges. So what I was hoping we could figure out over the next few weeks, number 1, is Mr. Gregory going to pick up the new case? And then number 2, let's clear up whatever confusion there is, and there seems to be some, about what discovery in the older 2 cases is still outstanding. I heard you very clearly, Ms. Hodge, you believe it's all been provided. Mr. Gregory seems to think he doesn't have some things. I don't need to get in the middle of that. I need you guys to talk, and you can educate Mr. Gregory on what he should have. He can let you know, well, I don't have that, but I would like, at least for the 17 and 18 case, to be ready to go, as I think they were in December of last year before I inherited Judge Reeder's cases. All of this is up in the air because of the unindicted rape, and I don't expect us to move forward on the 2 older cases until the new case is turned into an indictment. But we'll see. That Mr. Peck doesn't need to wait if he doesn't want to wait, if he wants his day in court. And his lawyer for the 2 indicted cases is right here on the phone. So what I'm going to do is ask you, Ms. Hodge, to chat briefly with Mr. Gregory in a breakout room. And then within the next couple of weeks, Mr. Gregory needs to let Ms. Nelson know if he is going to become counsel of record for the unindicted case, or if he's simply going to stick with the 2 older cases. Okay?
Understood, Your Honor. So just to follow up, so I make sure that I understand, I will make sure that he has all the evidence on the 17 and 18 cases, which he should, but I will confirm and get him, have our office resend what was sent that he may not have, and then just wait or speak with him in terms of the new case and whether or not he'll be moving forward to represent Mr. Peck on the new case. But I know the state's position is we would definitely like to hold off on the 17 and 18 case until we can get this new rape case indicted.
Okay, and I don't have a position on that one way or the other. It's really more Mr. Peck who would be driving that one. He's not going anywhere. So he may say, after he has a chance to speak with Mr. Gregory, that it makes sense to try to resolve all 3 matters. Who knows? Mr. Gregory, anything you want to add before I move you and Ms. Hodge into a breakout room?
I'm sorry, I was muted. Nothing further, Your Honor.
Okay, I'm going to put you 2 in. You're free to go after that. You don't need to come back into the main room. We'll be taking a plea. Thank you both.
Judge,
thank you, Your Honor.
Judge, can we give them a deadline? A deadline of October 30th for that, to him to get back with me?
Sure. So by the end, it's a little more time than I was going to give you, but by the end of October, Mr. Gregory, you need to let Ms. Nelson know whether you are going to assume the new unindicted case or not, okay?
Okay, Your Honor.
All right, let me move you guys. Hold on a second.
Hello? Mr. Gregory?
Somehow she's in two different
I
phones.
think her audio is on with a number.
Yeah, but let me see if I can move that to. There we go. All right, it's all in there. Okay. Let's do Mr. Johnson. Ms. Hall, are you ready?
Yes, Your Honor, I'm ready.
You ready, Mr. Forte?
Ready, Judge.
So Mr. Johnson is charged with aggravated assault and possession of a firearm by a convicted felon. Is this a negotiated plea, Ms. Hall?
It is, Your Honor. The state, for the record,
As charged, or are you reducing anything?
the state is reducing count 1.
You say that again?
Yes, I said the state is reducing count 1, aggravated assault with a deadly weapon, to reckless conduct, and a no crossing count 2.
All right. Hey, Mr. Gregory, you're back with us. Did something happen with the breakout room? All right. Good morning, Mr. Johnson. Still morning for a few minutes. You prepared to enter a plea? Okay. Ms. Hall, who you should be able to see on the big screen, I don't know if the little screen has anything on it. She's the prosecutor in your case, and she is going to swear you in just a moment. Once you're under oath, please answer all her questions and mine truthfully and completely. If you have any questions of your own, let me know. I'll try to answer them, or maybe something that you and Ms. Patel talk about. But you're free to confer with her if you need to do that, okay? All right, Ms. Hall?
Thank you, Your Honor. Mr. Johnson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Jonathan Johnson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 31 years of age and I plead GED.
You put your hand down now.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with aggravated assault with a deadly weapon being reduced to reckless conduct?
Yes, ma'am.
Do you understand that you have Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am, I have.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
We waive.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
Yes.
Mr. Johnson, have you been arrested on this charge?
Have I been arrested?
Yes, sir.
Yes.
I asked because the state is unaware of any additional warrants that are related to this case. Do you or your attorney know of any additional warrants or outstanding warrants that are related to this case?
No, ma'am, no warrants.
Okay.
The case, I got arrested like a month later because I was a victim. I got shot. Actually, I was a victim. I was the one who got shot. So I got arrested on that charge like a month later. I came and got me out of my house. But the day it actually happened, like the day the police report, I didn't get arrested. They arrested me like a month later.
But you
I understand.
were eventually arrested. Okay.
And Ms. Patel, you say you don't know of any additional warrants?
Ms. Patel, no other
Oh,
words?
sorry, no, we do not.
Okay. Mr. Johnson, have your attorney advised you of the minimum and maximum sentence for the charge that you're pleading to, which is 1 to 12 months to serve?
Yes, ma'am, she did.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court?
Yes, ma'am.
I'm sorry, a sentence of 12 months probation, but the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge, which is the 12 months probation.
Okay.
And also, Mr. Johnson, there is restitution in this case that we'll talk later with about the judge, but that is something that is expected as well, just at a future date. But do you understand that the court doesn't have to accept this recommendation from the state?
Yes, ma'am.
Do you understand this guilty plea is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance other convictions in this jurisdiction as well as other jurisdictions, including the federal court?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Okay.
You understand?
Yes, ma'am, I understand.
Okay. Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am, I understand.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, I understand.
Do you understand?
Yes, ma'am, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, I understand, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am, I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charge of reckless conduct in indictment number 20-SC-174045?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Be freely. Can you repeat that, ma'am?
Oh, I was asking, is this guilty plea freely and voluntarily given on your behalf with full knowledge of the charges that are against you?
Oh, yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of 5 felony convictions by the defendant dating back to 2010. I believe they all, majority except for one, dealt with drugs. The latest was a 2017 case. The disposition was April the 19th of 2018. That was also a violation of Georgia Controlled Substance Act statute, and that case number is 17 SC 154721, and he has 1 year, 6 months, and 20 days remaining. And had the state move forward, case proceeded to trial. Your Honor, the state would have proven that on December the 12th, 2019, at 3032 Stone Hogan Connection, Atlanta, Georgia, and Fulton County. Officers were dispatched to that location, which is a convenience store, in reference to a shooting. When they arrived at that location, they learned that there were two victims, or a suspect and a victim, and then another victim. What they found out on scene, they spoke with one of the victims that was there. She was sitting in her vehicle, Miss Finch. She was at a gas pump. She witnessed two groups, or not two groups, I'm sorry, the defendant and a group of guys shooting. These gunfires were going across her car, actually damaged her car in the process. And that is why Your Honor, the state is going to ask for the restitution to be determined. I need to speak with Ms. Finch about the amount of damages to her vehicle. We did receive a number of $11,738, but I need to get a little bit more details about that. So we're asking if the restitution can be determined later in the future, or we can have a restitution hearing, or I just speak with her and I'll get back to Ms. Patel about that. She is aware that I'm trying to finalize the restitution amount, but her car was hit in the gunfire. Later, officers investigated this case, and they were able to see on the surveillance camera that the defendant ran up through some wooded area or some trees to an apartment complex. He did get shot in the leg from the exchange of gunfire. He did tell officers that he was there selling drugs, and he felt like the guys that approached him was trying to rob him, and at some point somebody pulled out a gun on the other side, and the defendant said that he was trying to protect himself, and when they started shooting, he shot back. The state has been able to talk to the defense about the defendant's statements as far as what happened, and I also been able to talk to the investigating officer. They were able to review the surveillance, and they couldn't see how this incident started, but they could see that the defendant was running from that store and looked like he was running from someone that was shooting at him. With all the negotiations that we've had, me and Ms. Patel, we have, it's been pretty long negotiations where we finally agreed or came to a negotiated agreement of the reckless conduct, because although he may have been getting robbed, he is a convicted felon, so he shouldn't have had a gun. And then the gun play, because the victim, Miss Finch, who was in her car, she did have to get on the ground to try to avoid getting shot. Like I said, her car was actually shot. And she's watching as well, Your Honor, via YouTube. But the defendant was eventually arrested and charged with the aggravated assault. The other guys that were shooting at him, Your Honor, were never apprehended or identified. So that's why he's the only person on this indictment, and that is all from the state.
So what was the thought process of no processing the firearm by convicted felon? That to me seems like the easier of the two to work through. There may have been a self-defense angle here, and that would explain away the aggravated assault. But to your point, Ms. Hall, Mr. Johnson shouldn't have been selling drugs, but in particular shouldn't have had a gun on him, given his healthy criminal history.
Yes, Your Honor. Like I said, the negotiations have been pretty long, and we were pretty much stuck at that particular charge, the possession of a firearm charge, because of what I've stated. But in still receiving things and information from the defense counsel in negotiation, we just went ahead with everything that happened and the supporting evidence to show it. We went ahead and decided that it was best, with the defendant also being injured in this incident. And yes, we did acknowledge that he shouldn't have had a gun, and we actually thought about it, sat down, I spoke with my supervisor about it, and this was just the resolution that we all thought was the best in this case.
Okay. Ms. Patel?
Thank you, Judge. A little bit more context to the situation that happened at the gas station. So the 3 men involved have been terrorizing this apartment complex called Greenbrier Commons, which is right by this gas station. There were several reported burglaries in the area. My client's place was also burglarized, as well as some other neighbors. I believe they were burglarized twice. And so these individuals had approached him about whether he had any marijuana, whether they'd be willing to sell him any. And at that moment, he starts noticing that he's essentially being sized up for a robbery. As he's starting to walk away, one of the guys just opens fire. So he's running away, pulls out a gun, and the video shows as he's running away, he's firing back. I believe most of the damage was a result of the 3 to the vehicle was from the 3 men that were shooting at his direction. And my client did end up getting shot and then called the police when he was back at his apartment complex. Miss Nunley Finch, her story supports that. She says, she sees 3 guys start open fire. She immediately lays her seat down, so she's lying flat to avoid it, and that there was a break, and then the gunfire resumed again. I don't believe that these individuals have been caught, at least as it was related to the burglaries or even in this situation. But my client, as part of this negotiation, he did not intend to cause Miss Nunley Finch any harm, and he has been deeply apologetic that she, was in fear of her life at the time. He has been working for 3 years at the Marriott. Currently, they're on pause because there was a COVID outbreak last month, so they shut down. They intend to open in 3 weeks, but he has had stable employment while he's been there. He does have his GED. He has, I believe, he has a son that's 8 years old. He lives with his girlfriend who, when we had a bond argument, had brought the police reports regarding the string of burglaries that they had and how they talked about, the burglaries had occurred before this shooting had even occurred. And I should mention that when he was being sized up outside of a convenience store, he was wearing these expensive shoes called Yeezys. They're worth like $1,000. And that's sort of where this was coming from, because they saw that, they started asking him about it, and that this is something that they've been doing to the people at this apartment complex, and nothing's just been done, which has been frustrating for him and his girlfriend. I don't think that they live there anymore. But suffice it to say, there are several people that are being victimized by this group, and my client is very apologetic to Ms. Nunley Finch for what happened to her vehicle. We just haven't received anything at all as it relates to status of the car, damages, repairs. So we are more than happy to have this set for a restitution hearing in the future.
Right. Ms. Rolak, was there something that Ms. Finch wanted to share?
Good morning, Judge. Yes, Judge, she didn't want to make an actual written statement, but she did want me to convey to the court that she had experienced serious economic hardship as a result of this incident. At the time of the incident, she was working for her own, on her own, with Grubhub and delivering for Domino's. And so her vehicle was her way to make a living. And because of that, the vehicle was totaled, and the sum that Ms. Hall mentioned was what the totaled amount came up to. And since the incident happened and compounded with the COVID-19 crisis, she was left without work. And it was until recently, about 5 to 6 weeks ago, she said that she was able to get a rental that she has had to pay weekly to be able to continue her choice of career.
Okay. Well, I appreciate you sharing that. That is extremely inconvenient. I guess the good news is that Ms. Finch is okay. The car is not, but she's okay. She was not struck by any of these bullets, but it does sound like that was very disruptive to her livelihood. I appreciate you sharing that. Mr. Johnson, what Marriott were you working at?
Central Boulevard, 2000 Central Boulevard. One is like it's in Brookhaven, but it's Atlanta.
Okay. And these three guys who are burglarizing apartments and approached you at the gas station, who are they?
Actually, I've never seen the apartments I've been staying for 2 years. I actually was working, and my apartment got burglarized. This was 2 years ago, and it wasn't too long got burglarized, like sometime last year, like back to back. And okay, like she was saying, my birthday is December the 7th. You know, I work hard, so you know I wear my clothes. So I got shot. What it was? What the date? December 12th?
Yeah.
You know what I'm saying? I don't sell drugs. I work. I stay in apartments. The store like right there. I go to the store. I smoke cigarettes. So I go to the store like 2-3 times to get little singles. Don't sell drugs. Don't know where to get that from. Dude, these 3 dudes, you know, they approach me.
But you know, my question was, do you know those 3 guys?
Never seen them.
Okay.
Then look, I'm 31. Now I know they was
These are
in high
kids.
school. Yeah, I know because they ain't got no facial hair, tattoos, no facial hair. I knew they was young.
They're little ones.
And they were like, how much you pay for your shoes?
And you knew what that was about.
Automatically. So
Okay.
yes, I have.
All right. And you didn't know the young lady who was in the car, Ms. Finch,
No.
also a stranger. Okay. So if you don't sell drugs and you mind your own business and you work hard, why are you carrying a gun going to the store to buy a cigarette?
Okay. I've been shot multiple times. Been shot in my face. I'm mad. I've been shot. This was like 2009.
So this wasn't the first time you got shot.
And guess what? I'm a good person. I work, never took nothing, never stole, never got over. Why? I dress nice. I would be that people take nothing. And so that's why I have to protect myself. I've been like shot 4 times, my face, arm, back. I got a bullet still in me. So that's why I protect myself.
And you got hit in the leg this time?
Got shot in the leg with three balls. And I didn't want to come by my stuff. I tried to run, they got shot.
Okay. And you got hit in the leg?
I got hit in the leg because I'm running.
You were running in your Yeezys. So hopefully they got you home fast. All right. Well, Mr. Johnson, I find there's a factual basis for a plea to reckless conduct, and that your plea is knowing and voluntary. Do you have any questions of me?
No, sir.
Have you understood all the things we've been talking about?
Yes, sir. And thank y'all for opening our eyes and reasoning with me.
What I'm going to do is sentence Mr. Johnson to 12 months probation. If we need to amend the sentence to add a term of restitution, we can do that. But that would only be after Ms. Hall gets further documentation from the victim and shares that with Ms. Patel, so that it could be everyone agrees this is a dollar amount. And we've now heard Mr. Johnson makes good money. He's got fancy shoes, so paying restitution shouldn't be too complicated for us. But he ought to pay only what is due. And I appreciate your view, Mr. Johnson, that, hey, these little boys ought to be paying some of it too. We need to know who they are.
I tried, like, okay, and that's why the officer, the officer arrested me, because he trying to tell me that I knew him guy. And I'm like, sir, I've never seen the guy. I can't tell nobody I don't know. So he gave me like 3 weeks. I ain't giving him information. Come get out of my house a month later.
I gave you 3 weeks.
I tried. I understood. I'm like, man, he wasn't shot me, man.
All right, so count 2 is dismissed. Count 1 is reduced to reckless conduct. It'll be 12 months probation. And Ms. Nelson, how does Mr. Johnson connect with misdemeanor probation?
I will send a copy of the sentence to misdemeanor probation and the form to Ms. Patel for him to know who to get in contact with.
So your obligation is going to be to plug in with these probation folks. You are on felony probation already right now for this 2017 case. Misdemeanor probation is private. It's not run by the government. So you're actually going to have two different places you need to report. This one's only 12 months. You got 18 months left on this drug case for a guy who says he doesn't sell drugs. Got this open drug case. But that's it. I need to put all your names on this indictment. Normally we hand the indictment around and people sign it. Do you authorize me, Mr. Johnson, to sign your indictment for you? Normally you and Ms. Patel would sign it, but we try not to pass papers around. Okay, Ms. Patel, may I sign for you?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
All right. So we're good. Ms. Patel is going to get in touch with you about misdemeanor probation. You stay out of the way of the bullets, all right?
I'm sorry.
All right, I think that's it. We have the court. Yes, Ms. Crawford.
I have a question about the revocation for the 17 case. Are you going to address that, or are you?
Well, he just bolted.
Oh, he was gonna wait outside.
Okay, did you want to do something with the 17 SC case?
Yeah, we can move forward with having a revocation.
I mean, all we do is reinstate him on probation based on how this was negotiated.
Correct.
So how do we do that, Ms. Crawford? I appreciate you flagging it. I do not want him grabbed on a warrant for the 17 SC case, but all we're doing is returning him to probation.
So you're just going to continue him on probation?
Yes, ma'am.
Okay, so I'll just reflect that on the revocation.
Okay. All right, that works. So that just leaves Ms. Jacobs, and we're going to give, I guess, Ms. Snyder a little more time to try to connect with Ms. Jacobs.
I appreciate that.
Okay. So Ms. Nelson, we'll give Ms. Snyder a couple weeks since the state is offering PTI to Ms. Jacobs before we do a bench warrant.
Okay, Judge.
All right, I think that's it. Thank you, everyone. I will maybe see you tomorrow. Do we have a calendar? Yes, we have a Zoom calendar in the afternoon. So I'll see folks then. Thanks.
Thank you, Judge.